Hey, everybody. So, I get a lot of emails from fathers who love their children and get hammered in family court, like the email I'm going to read and respond to later in this video. Here's the problem: I'm not an attorney, and even if I was, in most cases, I wouldn't be an attorney in the states these fathers live. But just as importantly, practicing law or giving legal advice for pay in many states is a crime. However, if I'm working under the supervision of an attorney, then I can advise a client in that context. So, historically, I would contract to an attorney on a case-by-case basis and help clients under the auspices of that attorney's representation and oversight. This would be accompanied by an NDA, a non-disclosure agreement, to protect my identity and my involvement in the case. Because honestly, the feminist witch hunt is very real. However, with that said, I can provide a personal opinion rather than a legal opinion on what I would do in the same circumstances as those who reach out to me. However, usually, the emails I receive, they don't have enough information for me to form a personal opinion, and often, I just don't have time to go back and forth via email and gather the information I need in order to provide a credible personal opinion on what I would do were I in the same situation. Even more importantly, many of these people offer me large sums of money to help them, which is precisely the reason I created a Patreon Subscribestar Discord for those who support the work on my channel and elsewhere. At the $20 a month level, a Subscribestar subscriber or a Patreon patron can contact me for free, without charge, directly via Discord, and I can spend more time and share with them directly and discreetly in real time what I would do were I in that situation. Now, and this is important, my opinions are not and should never be misconstrued as legal advice. No one should ever substitute my personal perspective for the advice of a competent attorney. However, those who have sought my opinions have often told me later that it helped them a lot. This includes attorneys. You see, while I can't accept money from people to help them with their legal issues, I can accept money that supports my channel, which is a very different issue. Further, even if I could accept the large sums of money that are often offered to me, ethically, I wouldn't feel right in doing so, because many of these men have already spent many tens of thousands of dollars getting nowhere, and honestly, many of them can't afford the fees I normally charge attorneys for my services, at least not for the amount of time and effort it would take to fix their family law case. So, anyone who chooses to support my channel at the $20 a month level gets access to my Discord, with access to me directly as often as I can schedule it. I use this Discord to coordinate video gaming, discuss current events, and spend one-on-one time with Discord members to talk on any subject they approach me with. Sometimes this includes family law cases, and I do it free of charge. Now, at the beginning of this video, I said that I would be reading and responding to an email I received, but before we get started, let me state one last thing. I changed personal facts in this email to protect the identity of the person who reached out. Now that that's out of the way, let's get started. Hi, DDJ. I'm hoping very much I can get some legal advice. Willing to pay. I was so excited to come across you. Though I know you aren't an attorney, you know more than any attorney I've talked to. Not to mention, you aren't corrupt or anti-father like all the ones I've talked to were. I've been burned bad by the lawyers I hired. Maybe there are some who would actually be good advocates, but I've been robbed so far. I have 45 children. I live in communist Russia now, but the divorce was settled in the state of despair, where my ex-wife still lives. My ex-wife filed for divorce nearly 4 years ago, and after tens of thousands of dollars spent, nearly 2 years and 4 lawyers, I ran out of resources and had to settle for the best offer I could get. Despite being the primary care provider for my children prior to the divorce, and also the breadwinner working from home, I have the kids every other Friday night, Monday morning, and every other Thursday evening. I also was required to pay nearly $1,500 in total child support, alimony, and other expenses, including the majority of the daycare cost for when my ex-wife has the kids. This, despite only averaging about $3,000 in income over the 4 years since the separation. Prior to the divorce being finalized, I was ordered temporarily to pay the same roughly $1,500 a month. My ex-wife has worked for her divorce attorney, making roughly $3,000 a month, receiving $1,000 in food stamps per month, Medicaid, discounted rent, etc. Since that time, I have been trying to save up resources to get a modification. At one point, nearly a year after the divorce, I attempted a modification. The 3 older children, as ordered by the court, had been seeing a team of child therapists. 3 separate therapists, 1 for each child. After several months of seeing my children every week, 2 of the 3 counselors made me aware that they considered my ex-wife to be severely psychologically and emotionally abusing my children. They reported this to the guardian ad litem, the court itself, and to me, of course. They also gave the recommendation in writing that I receive full legal and physical custody and that my ex-wife be limited to supervised visitation. I hired an attorney. Unfortunately, I was not aware that this attorney happened to be friends with my ex-wife's attorney. I spent all of my money, and she never even got an affidavit from the counselors claiming that they were not willing to give an affidavit. The counselors told me that my attorney never even asked them. They emailed the attorney and CC'd me of their recommendation of custody and their belief that my ex-wife was seriously abusing the children to no avail. The guardian ad litem never even responded to them. I also later found out that she too is a good friend of my ex-wife's attorney and also a close friend of one of my previous attorneys, who she is now actually in practice with. In any case, I had no more resources and had to drop the whole thing. Fast forward to the present. Now, all 5 of my children, who are 14, 12, 9, 7, and 4, have been reporting to me not only very frequent emotional abuse, such as trying to convince them that they are autistic, have speech impediment, claiming other children's parents complain about them, etc., but also now physical abuse, kicking in stomach, smacking on face, nails digging into skin, etc. The 12-year-old, a straight-A student, has even kept a journal of such for more than a year now. Every week, the 4 younger children beg me to get more time with them, to rescue them from their mom. The eldest, 14 years old, does not ask me for more time very often, but he simply doesn't really care about anything at this point. He was first informed of me not being his biological father. The biological father was never present and refused to be on the birth certificate by his mother after he became critical of his mother over the divorce. This did not make him favor his mother in any way, but it began an emotional spiral that has now led to him failing in school, having severe behavioral problems in school, etc. He is not adverse to spending more time with me, but is, I would say, apathetic toward life in general, including where he is living at any given time. However, I am not sure what to do. Early on, my ex-wife was physically abusing the children. I reported it to Child Services. Child Services came. My ex called her attorney. The attorney, the former crisis attorney in the area for abused women, clearly was well known to the Child Services agents that came. Despite my children saying what my ex-wife had done, the Child Services agents left without doing anything, and no further follow-up was conducted. My attorney at the time did nothing. So, I don't know what to do. I only have a couple thousand saved up again from the last massive defeat. I want to protect my children and report this witch for her abuse, but I fear it'll end the same way unless I have legal representation with a clear plan on how to actually defend my children. I anticipate being able to save about $1,000 a month from now on, but that is chump change. I spent $60,000 in the divorce and another $10,000 in the attempted modification and was woefully short on funds in both situations. Here are the points in my favor as I see them. My ex-wife is physically and emotionally abusing my children, which my 4 younger children at least would tell anyone. Number 2, there are still the counselors out there willing to attest to their observations and recommendations. Number 3, several of my children's school teachers are willing to testify to my ex-wife not giving them proper guidance or assistance with their schooling. Number 4, my ex-wife lives in a tiny 3-bedroom apartment with the children. My mother has moved in with me, and we are able to afford a 3,000 square foot house with a separate bedroom for each child and 5 acres of land. Number 5, my ex works until 5:30, so she has to have the children in daycare during the summer all day from 8 a.m. till 6 p.m. and in the school year from 3 p.m. till 6 p.m. She somehow gets the government to pay for 75% of this. I have to pay for nearly all the remaining 25%. When the children are with me, they do not have to be in daycare at all. During the school year, I can pick them up from school myself and do not even need my mother's assistance. During the summer, I have approval to work from home as much as necessary and work whatever hours I choose so that I can provide the primary care to all the children most of each day, assisted by the children's own grandmother in a comfortable home. Number 6, my ex-wife has spent thousands of dollars flying out to Massachusetts to visit her boyfriend multiple times over the past 2 years. My child support dollar at work. Number 7, my ex-wife has needed me to cover for her on well more than 50 of her parenting days at this point for a variety of reasons. She has also had babysitters for the children on numerous occasions, even when she is off work. I have never needed her to cover one of my parenting days in 4 years, not even 1 minute. On the negative end, number 1, she works for her divorce attorney. Number 2, she seems to have a never-ending stream of money for whatever she wants, I believe from her family members. Number 3, the guardian ad litem is still assigned to the case, despite working with one of my old attorneys, and she is not only good friends with my attorney, but I owe her $30,000 for her services as a GAL. I paid her more than $15,000 already. She gave that as her reason for not responding to the counselor's report, i.e., I owed her money. Interestingly, she continued to be in contact with my ex-wife's attorney on the case. So, what can I do? Thanks, frustrated father. So as you can see, frustrated father was the primary care provider and he was the breadwinner. He still lost custody anyway. I want you to think about that. The other thing you should consider is this. He's not only paying child support, but he's also paying alimony. Now, before we get started on the rest of it, let me say one thing out of the gate. If the counselors reported the abuse to CPS and child services, and they did nothing about this, they can actually be sued for child negligence by the children and by the father, typically until the children are, I believe it's 21 years old. Now, you're going to want to talk to an attorney about this, but I believe the statute of limitations for suing child services is usually 3 years after the children turn 18. So usually it's 21 years old. But if the children were harmed from it and Child Protective Services had an opportunity to step in and chose not to, then this is suable. And I can tell you, frustrated father, the state that you're in, many families have sued child services successfully for much of the same conduct that you're dealing with in your case. Now, let's talk about what you see as negatives, and let me tell you why I see them as positives. Now, first and foremost, your ex-wife works for her attorney. She gets approximately $3,000 a month. Plus, she gets food stamps and public housing assistance, free state medical insurance, and on top of all of that, she gets about $1,500 a month from you. So she's really, in reality, after taxes, if you really want to take a look at it, she's getting the equivalent of about $70,000 to $80,000 a year once you add in everything together. Now, the 3 older kids were in therapy. 2 of the therapists reported abuse to the guardian ad litem, to the court, and to you. Now, they're not only mandatory reporters for the court, but they are also, as therapists, mandatory reporters to child services as well. So there should be child services reports from these therapists also. Now, it's interesting that they recommended supervised visits with mom and full custody for you. And what's also interesting is that the court ordered this therapy, but it sounds like the court ignored the supervision recommendations and the custody recommendations of the therapists. Now, let's talk about something else. The attorney this frustrated father hired was personal friends with his ex-wife's attorney. This was never disclosed, and he only found out later. In addition to that, this attorney never got an affidavit from the counselors, never attempted to subpoena them for a deposition or for records. So in other words, this is an excuse attorneys use. They say, oh, well, I asked them to do a declaration or an affidavit, and they said no. Well, I don't care. Fuck you and the horse you killed to get here. Okay? Send them a goddamn subpoena. Send them a subpoena. That is what it's there for. And if the witness wants to be hostile, you contact the court and you say, Your Honor, can I treat these people as hostile witnesses because they're assholes? That's how you handle that. But in this case, the attorney lied to frustrated father because frustrated father says that the counselors reached out to the attorney, CC'd the father, the attorney never responded. Now, the other thing that's a concern here as well is that his attorney never subpoenaed the guardian ad litem for records. I can't tell you how many times I see this and how completely frustrating it is. It's like these attorneys who have 7 years of education and 3 years of law school, obviously part of that 7 years, they're booger-eating morons, okay? Like if you have a parenting investigator in your case or you have opposing counsel in your case, you send discovery to them. In the other side with the ex-wife, you send her interrogatories. You send her, requests for admission and denials in addition to subpoenas. You do this for the guardian ad litem as well, if the guardian ad litem is considered an attorney for the children or a parenting investigator. In some jurisdictions, they're considered a party. In other jurisdictions, in divorce, they're considered fact witnesses. Doesn't matter which one it is. It's just you do discovery. It just depends on what that discovery looks like based on whether or not they're considered a party or whether or not they're considered a fact witness. So when it comes to this, you do the discovery on the GAL like you would for anybody else. And most family law attorneys don't do discovery at all. They take their head, they shove it promptly up their ass, they walk into motion hearing, and then they walk out with their ass kicked trying to figure out what the hell happened. Well, you know what? If you'd fought, you'd know. So this is a problem with family law attorneys all across the board when it comes to defending fathers. They just don't do it. And the majority of the time, it's because they hate men. But there are good family law attorneys out there who don't hate men. They just don't know how to do it. Now, here's the other concern. The guardian ad litem was also friends with the ex-wife's attorney and probably is an attorney also. Now, the other concern that I have is that the boy was told by the mom that this frustrated father was not his biological father. Now, even though this may be true, he's still the father on the birth certificate and he took responsibility for this child. Now, I'm not saying that I would make the same decision, but this is the decision that this man has made and he is raising this child. So for the biological mother to do this, this is parental alienation and it is emotionally and educationally harmful to the child, as outlined by frustrated father saying, look, the kid's having school problems and everything else. These are grounds for modification. Now, here's what I would do in this situation personally. I would collect all my records in one spot. And then I would contact child services. I would get copies of service episode reports. Usually when a father contacts child services for records, child services doesn't give up everything. So you've got to ask for service episode reports, contact reports, and all data and notes received, not just from the caseworker, but from the caseworker's supervisor. This is typically done under the Freedom of Information Act. It's a Freedom of Information Act claim. Most states have a state version of the Freedom of Information Act, which requires them to give you all records, including records on the children as well, since you are the biological father. If they don't do this, they can be sued in civil court for failure to do so. You can not only fine them for this, but it usually covers attorney fees also. Now, these types of lawsuits, in my experience, are usually very cut and dry Freedom of Information Act lawsuits, and they can earn a significant amount of money to build a war chest needed to protect this man's kids. Now, in addition to that, get evidence of your former attorney's friendship with the other attorney and file a bar complaint in that state. In many jurisdictions, these types of relationships violate the attorney rules for ethics and can sometimes force the attorney to refund your legal fees. The basis of the complaint is conflict of interest and refusal to act on evidence of child abuse while representing you. Basically, it's negligent assistance of counsel. I personally have helped file many of these complaints, and they work more often than people realize. Also, get evidence that the GAL is friends with the other attorney. Make a motion before the court to have the GAL removed from the case for concealing her friendship, which is a conflict of interest. And if this GAL, if this parenting investigator is also an attorney, this is also a credible bar complaint against that attorney. So request the court refund all fees paid to the GAL and request that all GAL reports from this GAL be stricken from the record due to actual evidence of bias and conflict of interest. This includes vacating any orders from the court based on this GAL's recommendations under the same grounds. Now, let me explain something to you about evidence. This evidence can't be, hey, I think that she's friends with such and such, or I think he's friends with such and such. This has to be independent evidence that can stand on its own. Once you have it, file it, make it part of the record. Next, prepare to take your case to the Court of Appeals. The trial court will be pissed that you're bringing these issues to their attention, and I have often seen the court retaliate against fathers for bringing these facts to light. So, prepare for the Court of Appeals on the first day you start gathering your evidence together. This means making sure your attorney protects the record for appeal, which means timely making court objections both orally at hearings and in writing should the other side submit pleadings with objectionable material. Many family law attorneys miss this, and I have seen many Court of Appeals appellate rulings come down and say, the record wasn't protected, you're right, but there's nothing we can do, you lose anyway. So you make sure you protect the record in your case at the trial court level. And you jump on your attorney's shit if they don't do it. Because again, this is negligent representation. This is litigation 101. Now, let's talk about fraud, attorney-client privilege, and how fucked your ex's attorney and your ex herself may really be. You said that your ex works for her attorney. She makes about $3,000 a month and always seems to have money, even though she's getting public housing, state medical, and other forms of welfare on top of child support. This could be welfare fraud. Now, the attorney that you get files a subpoena and gets all your ex's bank records everywhere. In addition to this, because the court requires your ex to file financials, your new attorney can subpoena the law office of her attorney for bank records, employee records, and other records related to your ex's employment. Now, here's the funny part. This supersedes attorney-client privilege because your ex's finances are always a credible issue in family court. And the fun part is, it fucks her attorney completely because it makes the attorney and everyone who works for the law firm a fact witness. An attorney cannot represent a client and also be a fact witness in the case. So this is often a bar complaint the attorney cannot win because it's an ethical violation. So have your new attorney do two things. Subpoena all employment records from the law firm that your ex works at, and then make a motion before the court to remove that attorney and that law firm from the case for being a fact witness. Because fuck you, that's why. Then file subpoenas with the welfare offices responsible for your ex's welfare. Reconcile those with your child support, alimony, and compensation from the law firm, as well as her bank records. and then use this evidence to report her for welfare fraud and request to have her jailed. And then once you have all that evidence, you file contempt of court with the family court and you seek to have her jailed there as well for lying to the court and everyone else about her finances. And then after you do all this, you watch her and everyone else around her lose their shit. Now at this point, you should be prepared to pick up your kids, because if you execute this correctly, you will not only win, you will salt the earth around your ex, the GAL, your former attorney, your ex's attorney, and it will be a cautionary tale told in that courthouse for years to come about how one loving father saved his kids and destroyed everyone who stood in his path. And just know this, it's an uphill battle, and any attorney you get, you make sure they're in it for the long haul, including the appeal. And you make sure they have good court experience. Usually criminal attorneys are good because they not only know when to object, they know how to preserve the record for appeal. Good luck. Now, this letter is relatively typical of the mail I receive from fathers in need. While this father included a lot of relevant information that helps me form a personal opinion on what I would do if I were in that situation, not all fathers are in a position to do that, which is part of the reason my Discord exists. If you want to support my channel, consider becoming a Patreon or a Subscribestar subscriber. And if you can afford the couple bucks to join, my Discord is always available, day or night, because at the end of the day, all men have is each other. I'm DDJ, and this personal opinion and response to this dad in distress is your dose of misandry today.